Hello everyone, welcome to my channel. If you are new, here I am Hidayahraziap and I'm your lecturer for this semester, and I am looking forward to discuss with you today a very interesting topic, a topic that is not only applicable to me but to you, especially the future you, and especially the normal citizen and normal people like us, and also it will impact you later on in your professional career, be it if you're a manager at a hotel or a tourism office, if you're a freelance artist, or if you are an employee or if you're an employer at a company. So it affects everyone. This is law of contract part 1. Okay, and law of contract is one of the oldest law that can be found. Okay, and it is so old that you can find so many old cases for it that we will discuss later on in this chapter. So under this chapter or topic, we are going to learn, we are going to divide it in basically two big division. Okay, the first one is how do you form a contract or the elements of a contract, and the second one is how you break a contract and what are the factors that break a contract, or what we call as a breach, okay, of contract. Okay, so that is basically the major division of our this topic in this coming week. So I hope you guys are ready. Okay, get your papers or your tab down for you to write down any of the explanation or question that you would want to ask during your tutorial question. Okay, now let's begin. Okay, so what is law of contract? What is contract? So contract in Malaysia is governed under Contracts Act 1950. So you can find that out under www.agc.gov.my. Download it for easy reference later on. Okay, so this is the codified law where we can find matters pertaining to contract in Malaysia. Okay, but if I know I have a few international students this round, okay, please know that the concept of law of contract is basically the same throughout throughout the world, the parts of the world. Okay, the basic or the essence of law of contract is usually the same. Okay, so let's look of what is the meaning of contract. So contract is under section 2. Okay, now open up your section 2, or you can go to your contract site that you already downloaded. You look at number 2. Okay, so section 2 of the Contracts Act, okay, define contract as an agreement enforceable by law. Okay, so it is an agreement, but it is another type of agreement that if the parties do not perform, you can enforce it. Okay, you can enforce the contract through law. Okay, so that is the difference between a normal agreement, okay, and contract. Contract, you can do something about it if either of the parties do not perform. Okay, so you see, it's much more serious. Okay, so when one party fails to perform his side of the bargain, he is said to breach, okay, or break the contract, and the other can bring the action to court. Okay, contract can be orally or in writing, and in Malaysia, the law of contract is codified under Contract Act 1950. Right? Okay, so like everything else, okay, in contract also, in order for it to be enforceable, in order for it to be valid, okay, you need to have this 6 element, or what I call as 6 ingredients. Okay, if you're cooking curry, if you're cooking bak kuteh, if you're cooking fried rice, okay, you need to have certain ingredient, okay, for that dish to cook up. Same goes to contract. In order for it to be valid, you have to have these 6, okay, elements. So what are those 6 elements? So the first one is offer, followed by acceptance, then consideration, intention to create legal relations, capacity to contract, and certainty. So in today's talk, I would like to go all 6, okay, so you get the whole idea of how to form a valid contract. Now, why some student would ask, what is the significance of learning a valid contract or not? At the end of the day, okay, one of you will at least have to sign a contract, be it formal, be it informal, but usually the one that we sign, okay, when hiring or be hired, that's a formal contract, or getting a freelance job, that's a formal contract. So we have to at least, at the back of our mind, know what makes it valid, what makes it stand. Okay, so these are the 6 elements that make up a valid contract. So let's look at the first. Usually the first elements are the heaviest one. You will look, okay, later on as we discuss copyright, and later on, usually the first one is the heaviest one. Same goes to contract. The first element is offer. All right. So what is offer? Okay. Section 2, subsection A of the Contracts Act. Okay. It says that when one person signifies to another his willingness to do or to abstain from doing anything with a view to obtain the assent of that other to the act or abstinence, he is said to make a proposal. So you see here the word, okay, under section 2A, they don't use the word offer. Instead, they use the word proposal, which is inter alia, which is a good, the same or synonymous to offer. So here it defines offer as when you show somebody, okay, when you signify to someone that you are willing to do or not to do something. Okay, that is offer. Showing someone that you are ready to do or not to do something, and you are just waiting for his acceptance. Okay, the best examples for it, okay, you are willing, for example, you want to sell your old computer, your second computer, maybe for 500 ringgit, okay, to your other friends, because you need that money to buy another new computer or another new laptop. So what you do is show your willingness, okay, to sell, okay, to part, okay, to give away that computer for maybe 500 ringgit. Okay, so you show to your friend, hi everyone, okay, or maybe hi Abu, ho I Hali, or hi Ahok, I'm willing to sell this second-hand computer for 500 ringgit. And then you are saying that while waiting for the other party to say his acceptance. So that is basically what I can give you a brief, okay, an example of what is an offer. Okay, an offer is what we call as the most important, one of the most important elements, okay, in contract, because under the case of Affin credit against or and Yap Yun Fui, in this case, the court said that if there is no offer, there's no acceptance, the basically the contract is void ab initio. What does it mean? It means that it was never there. Okay, so it means that if there is no offer, if there's no acceptance, the contract will not be valid at all. So these are one of the few important, okay, elements, okay, to start with. Okay, so an offer must be communicated. So you need to communicate, okay, your offer to your offeree, meaning that the one that supposed to accept the offer under section 4, subsection 1. Okay, next, we have 2 types of offer here. Okay, we have unilateral offer and bilateral offer. So unilateral offer is something that when you make an offer, you are ready and willing, but you are not sure who will take your offer. Okay, for example, I make, okay, an announcement in Facebook, I'm selling my computer for 500 ringgit. Okay, anyone, or maybe tell that anyone who would like to, paint my house for 500 ringgit, please come. And then if someone come, okay, for example, one of your friends or one of the vendor, okay, one of the technician came and paint your house, okay, so that is unilateral offer. So you don't know, or you don't offer it to a specific person. In fact, okay, you are posting it or offering it to the world at large. Okay, same goes to this example. Okay, for example, you put a poster, okay, of your pet, you lose your dog or your cat. Okay, so you put there lost pet, 500 ringgit as the reward. So so you did not offer that offer to a specific person. Okay, so if someone found your cat or your dog and give it to you, you need to honor the 500 ringgit offer. Okay. All right. Next, we have bilateral offer. Bilateral offer is when you know someone that specific, okay, that will accept or not accept your offer. So it will be addressed to that person only. Okay. All right. So there is another concept, okay, under law that it is not offer, but it is similar to offer, but it is not really offer. It is what we call as invitation to treat. Okay, invitation to treat. As opposed to offer, it's a little bit different in a sense that when offer, we show our readiness. You know, man, I'm ready to do this. Okay, I'm just waiting for your acceptance. But invitation to treat is not. So you have to be careful whenever you look at what you call as an offer that you see maybe online or offline. You have to take a step back to think that whether this is offer or invitation to treat, because invitation to treat is a non-binding statement. They are not showing readiness. They are not showing that, hey, I'm ready to be bound by my words. No, it's just usually most of the time a statement of facts to invite offer. Usually, the person just will tell you, hey, I have this. Okay, just displaying something, but there is no further offer for that. For example, okay, catalog. Okay, when someone goes to you and, hey, this is our catalog for this season. Okay, so catalog are not offers, but it shows you that, hey, we have 500 design with various specs. Okay, so these are the price, okay, in that catalog. Okay, so a catalog is not an offer. It is invitation to treat. Also, we have auction. Okay, auction, lelong, 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 lelong. Okay, for example, auction. So you show maybe an old vintage car. Okay, so the auction show, okay, auction starts at 1,000 ringgit. So 1,000 ringgit, okay, is just the price, the base price of that car. So the offer must come from you. So you raise your hand. 2,000 ringgit, and the other guys at the back 3,000 ringgit. So you are making an offer instead. So the auctioneer didn't make an auction. You are making an auction. You are an offer. Okay, so the concept needs to be looked at. Usually the wording, okay, in that invitation to treat. Okay, so if in that wording the person shows that, hey, I'm willing to sell this. So show that he is wanting to sell it to you for certain price. Now that is a clear-cut offer. But if someone just display computer 500 ringgit, if that is just the word or the poster, it is not an offer. It is merely telling you, hi, we have a computer 500 ringgit. So you must come to that person and say, hey, is this computer for sale? I would like to buy it. Okay, so this is very dangerous in the sense that later on, I don't want you guys, especially in signing or accepting on contracts, you don't be confused whether this person is giving you an offer or invitation to treat. And for artists, okay, or for designers, okay, usually people will come to you. For example, your client will come to you, hey, I want you to design a comic character for me. Okay, and can I know your quote, or can I know your quotation, or can I know your mark, your price, okay, point for that. So when you answer to your client, okay, or your prospective client, you say that, oh, for this kind of project, we will usually look at 30,000 ringgit, for example. So while giving that number for them, you are not giving them an offer or an acceptance. Okay, that is basically quotation. Okay, so when you give someone a quotation, that is not, okay, an offer. Okay, that is just a statement telling that is the price, okay, of what you guys are asking. Okay, so there are so many cases that distinguish between offer and invitation to treat. So your job, okay, for this one, I want you guys to take a look at the case of Harvey and Facey, and also the case of Pharmaceutical Society of Great Britain and Boots Cash Chemist. Now, I want you guys to go back and read this case. There are a lot, okay, of what we call of reference, okay, online, so you can take a look at it. You just Google the case, Harvey and Facey or Pharmaceutical Society of Great Britain, okay? So you find out about this case, we are going to discuss it during tutorial. Okay, moving on next. Okay, this is the case for unilateral offer. Remember unilateral offer that we discussed, that one is bilateral, you make it to a specific person, and another one, okay, you make it at a whole world at large with no specific person in mind. So bearing that in mind, this is the best case, the landmark case, which is founded under which was decided in 1893. So that is like, wow, more than 200 years ago, like 100 years ago. So this case is a landmark case for unilateral offer. This is also the case that I want you guys to read, okay, so that we can discuss, and for you to appreciate better what is the difference between unilateral offer and invitation to trade. All right. Okay, so an offer can also be revoked or withdrawn anytime before the other party gives the acceptance. Okay, and you must give a notice of revocation to the offeree for it to be effective under Section 6, subsection A. Okay, so a revocation can also happen in the following circumstances. Okay, for example, lapse of time. Okay, offeree failure to fulfill the condition of the offer, and death or mental disorder. Usually lapse of time, okay, for example, is you put up an offer, okay, I'm selling this computer for 500 ringgit, okay, and the sale is up until 6 p.m. today. Please reply by then, or else I will take back the offer. So when it is after 6 p.m. and nobody give you any acceptance to that offer, so basically that is lapse of time. Okay, time is up, so the contract timing, the offer is automatically revoked or withdrawn. Okay. Also, offeree's failure to fulfill the condition of the offer. Okay, so this is when you have a conditional offer. A conditional offer is something that comes with a condition that if you do not fulfill the condition, so the offer is not valid. So for example, you have an offer, a conditional offer for a scholarship, that in order for you to get the scholarship, you must get 3.5, okay, CGPA throughout the semester or throughout the year of your study. Okay, so if you fail to fulfill that, okay, so the offer can be revoked. So be mindful of the condition, okay, of an offer. And death and mental disorder. Okay, if in case the person the person giving you an offer suddenly died, you cannot enforce it, okay, towards that person. Okay, all right, so that is the first element, okay, an offer. So from the first element, we move on to the second element. So the second element is what we call as acceptance. So acceptance, okay, is when someone under Section 2, subsection B of the Contracts Act 1950, when the person to whom the proposal is made signifies his assent thereto, the proposal is said to be accepted. A proposal, when accepted, becomes a promise or an agreement. So it shows here, okay, after someone has showed you an offer, okay, so an offer, okay, is met with an acceptance. All right, so when an offer is met with an acceptance, i.e. accepting whatever the condition of the offer, it is called an acceptance. So under Section 7, acceptance must be absolute and qualified. This is very important for the second element. When you accept, you have to accept the offer absolutely and without qualification. So it means without condition. Only offer can put condition, but acceptance, you need to accept it on its entirety. Okay, because okay, what happened if you don't agree with the terms of the contract, okay, or the terms of the offer, and then you put some other offer against it. This is what happened in the case of Hide and Wretch. So in the case of Hide and Wretch, the person put, okay, to sell, okay, I'm offering, okay, the plaintiff to sell the farm for $1,000 or £1,000 at this time. But the plaintiff said like, hey, plaintiff do not agree with it, and instead of accepting, he put up another price, which is £950. Okay, so the defendant refused to sell his farm at the reduced price, and then the plaintiff turned around and said he would buy the farm for back to £1,000, and the defendant still refused to sell the farm. So here, okay, what happened here? Okay, at first, this is true. This is an offer. Okay, the defendant wants to sell his farm for 1,000, but it was not met with an acceptance. Instead, it was met with a counter offer. This is what happened when you don't accept, okay, the offer as absolute and qualified. It doesn't become an acceptance. It becomes a counter offer. Okay, so an offer met with a counter offer, there's no acceptance to begin with, so meaning that there's no a real agreement. Okay, so an offer must be met with an acceptance. It must be absolutely. Okay. Okay, acceptance must also be communicated or brought to the notice of the offeror. Who is an offeror? Is someone who offers, okay, and offeree, someone who accepts. All right, acceptance can be made through words or conduct. Okay, all right. So I'm not going to touch on letters and telegrams because that one usually it's rarely happen, especially in a digital world like us. Okay, an offeror may specify the method of acceptance, and the offeree must communicate his acceptance through the specified method. For example, okay, I'm the offeror. I put up, okay, for this scholarship, you guys must reply through this email, okay, right here, and then you must follow that condition of the offeror. Okay, an offeree can withdraw his acceptance only if the acceptance has not been communicated to the offeror. So now, basically, it is said that you can, as long as the acceptance has not reached, okay, the offeror, okay, when you say I do or yes, okay, or you accept, okay, as long as it does not reach the offeror, the one who made an offer, you can still take it back. But that is usually really hard when usually you say you accept the contract, okay, you sign it, that is already a clear acceptance to it. So before you say I do or you accept, so that's why you need to read all the conditions and also whatever is laid down, because when you accept, you have to accept it in its entirety. Okay, so that is it. Okay, these are the things that I want you guys to remember now, because whatever that you guys do now will affect you in the future also. Okay, all right. Okay, next is consideration. Okay, the third element is consideration. Consideration is a value for a promise. When someone is willing to give value of a promise, it shows that he takes the deal seriously and intends to be bound by it. Okay, so consideration is what makes a normal agreement and agreement enforced by law, i.e. contract. Okay, that makes it different lah. Okay, a normal agreement, maybe you just agreed without really meaning it, without having consideration. But okay, an agreement with a consideration shows that you are serious, okay, about it. Okay. All right, if you can hear like some motorcycle or someone drilling, I'm really sorry, but I need to do this, okay? Or else I don't have time for it. Okay, going back, okay, consideration is an exchange, okay, a value for a promise. Meaning that when I do promise, for example, hidayahraziap, okay, want to part with her old computer for 500 ringgit. So my consideration, my exchange, that promise is that old computer. and your exchange or consideration to that promise is the 500 ringgit. So when we agreed to that, okay, so we are said to be exchanging consideration. Okay, all right. So general. Now this is the tricky part, okay, of the consideration concept. Under section 26, subsection A, okay, an agreement made without consideration and made under account of love and affection is not void. Okay, now this is the what we call as an exception. Okay, an exception is even though they said that every agreement or every contract must have consideration, but there are exception. Exception is where it is made under the account of love and affection. So when your father and mother, okay, give, okay, or bequeath, all right, or inherit some lands to you, okay, so you can, and it is made out of love and affection, meaning that you didn't pay your parents for that. Okay, they give you out of love. All right, so that is still considered a good contract. Okay, and also okay, let's move on to the next. Okay, also under section 26, okay, you can find in Malaysia, past consideration is a good consideration. Okay, past consideration is where, okay, even you, before you made the offer, the person already did the action first. Okay, for example, okay, you have a really ugly bathroom or maybe bedroom, so your friend come over and painted the whole bedroom, okay, painted the whole bedroom, and then you were so like touched by his action, and you said like, hey, thank you for painting my whole room, you know what, I'm going to pay you 500 ringgit. So even though the 500 ringgit offer came after the action, okay, it is still a good consideration. Okay, it is still can be made, and you would have to still pay your friend. Okay, so next time later on when someone did something good for you, just say thank you lah. Okay, all right, especially when he did it voluntarily. Okay, next, consideration can move to a third party. What does this mean? Okay, for example, if I sell to you computer 500 ringgit, okay, that consideration, that 500 ringgit can come from your mother. Okay, can come from your father, can come from a third party, and that is okay. Somebody can pay that for you, no problem. Okay, so that is what it meant. Okay, so okay, this is a cool concept of consideration need not be adequate. Now, consideration need not be adequate, meaning that the court will not look at the amount of exchange. Okay, so long there is an exchange, although how small, the court might accept it. Okay, because in contract, the court allows for the party to set how much of the price, okay, what are they willing to give and partake with, okay, in that contract. Okay, so the amount, the court will not look at it, okay, but suffice there is an exchange, okay, or something of value, that is enough. So this is explained in the case of Chapel, again, Nestle Company Limited. So these are also the case that I want you guys to read, okay, further, and we will discuss it in our tutorial. Okay, so tutorial is a special part when I ask everyone around, okay, to explain, okay, what they understand from a case. All right. Okay, and consideration need not be adequate can also be found under the case of Kepas Singh and Bariam Singh. Please also read this case for consideration, okay, and for our discussion. If you don't understand any part of it, keep that question, write it down for me and you to discuss in our tutorial. Okay, next, the fourth element, okay, the fourth ingredient is the intention to create legal relations. So, intention to create legal relation is when two parties, okay, really have the intention, okay, to create legal relation, to ready to be bound, okay, in the agreement, in the contractual agreement. Okay, so when you are ready to be bound by that contractual agreement, if any party fails, all right, the other party can enforce, okay, the contract in court. Okay, so in law, to determine the party's intention, we apply an objective test, okay, whether a reasonable person looking at the party's words and conduct. Now, this is very important, okay, to know whether these persons are serious, these parties are serious or not. We look at the words and conduct, okay, and whether we would consider those words and conduct to show intention to create legal relations. Sorry, there is a typo that it's not top create legal relation, it's to create legal relations. Okay, so as a general rule, okay, now this is something that you have to bear in mind. Okay, as a general rule, in creating legal relation, if you are in a domestic or social agreement, the court will not, or the court will look at it as not having seriousness or not having intention to create legal relation. Okay, because in a social or a domestic agreement like husband and wife, okay, mother and daughter, son and fathers, okay, the court will say that, hey, this is, they are not really meaning to say that they want to be legally binding by their words. Okay, for a simple example, you got a really good what we call as result. Sorry, my mind just went off there. Good result for SPM or any kind of test, and then your father or mother came to you and said, "Hey, you're being very good child. Okay, your result is and your performance is in your study is very good. I might want to give you a new car, for example." Then maybe something happened, okay, and your father or mother did not buy you the new car. Can you sue your parents? Okay, this is why this kind of thing is important. Okay, so here under the case of Balfour and Balfour, okay, the husband promised to the wife, okay, allowance of $30 per month, okay, but later failed to pay the allowance, okay, and the arrangement was not enforceable. Here it is not enforceable, okay, because Mr. Balfour never intended for it to have legal force because they are husband and wife, you know, and also in the case of your father and mother fail to buy you a car, okay, because the court will look at the relationship, okay, as a social and domestic agreement. The court will say that, hey, there's no real intention. It's just maybe just 2% in a relationship promising something. Okay, but okay, you can still make, okay, even though it's your father, even though it's your brother, even though it's just maybe your mother-in-law or son-in-law in the future, you can still make it work. Okay, again, this is where you fall down back to the words and intention of the parties. In married against married, even though they are a married, you see the pun there, married, even though they are a married couple, okay, this agreement was found as enforceable. Why? Because the wife is smart. Okay, the wife basically, the husband basically said to the wife, "I would transfer the house to you, but if you pay the mortgage in installment, meaning that you pay monthly, okay, for the house." Okay, so the agreement between husband and wife was put under on paper. So the wife is smart, so the wife paid the installment months after months, but later on, husband refused to transfer the house. Okay, but okay, because the wife put it all in writing, showing seriousness, okay, to that agreement, even though they are in a social or domestic agreement, okay, the court find that there is intention to create legal relations. Okay, as opposed for social and domestic agreement, when you are in commercial agreement, the court will presume that you are serious to be in your to be legally binding, okay, or to create legal relation. So that's why when it is a commercial agreement, buying and selling things, company A and company B wants to order something from you. So the court will take it as serious and will take it that you have, okay, intention to create legal relations. Okay. All right. So next, the fifth, okay, ingredient or the fifth element is capacity to contract. So capacity to contract is what we call as eligibility, qualification to enter into a contract. But in Malaysia, okay, basically is, I think, more or less the same in other countries as well. Maybe a bit different in the age. Okay, is someone that is firstly, okay, have the ability to understand the contract terms and can give his free consent. Now, this is very important. Okay, only when you truly understand the term of the contract and can give your free consent. Free consent means that you are not forced to do it. You have the mental capacity to understand it, okay, without being coerced, without being manipulated to enter into that contract. So this is really important. Okay, so how do you say that someone has the capacity? Usually someone who is a sound mind, okay, they are a good mental capacity and also of the age of majority. Okay, so that's why under section 11, person who is a minor. Minor is someone that is not, okay, at the age to make a contract, okay, which is 18. Okay, that is the basic age. Okay, and also unsound mind, meaning that not in a mental capacity, not, is to be said that this person has no capacity, meaning that has no qualification to enter into a contract. Okay. A person who is incapable of understanding the agreement and cannot rationally judge the effect of the agreement on his interests, that is what we call as person as unsound mind under section 12. Okay, so this person are unqualified, okay, to enter into a contract. That's why, okay, sometimes in the deathbed, okay, when someone is mentally unstable, okay, he's really sick, he don't know what he's signing, so you can basically challenge, okay, the contract. And sometimes people do challenge contract based on this, meaning to say that because this person is sick while he's signing, he didn't really know what he is signing, so you can actually challenge the contract under section 12. Okay, and a minor, okay, anyone who is 18 years old, we are calling him a minor. So basic or a general rule says that a minor cannot enter into contract. Okay, you cannot contract. So that's why mostly if any one of you enters any contract before you are 18, okay, usually there will be your father and mother, okay, to be your guardian and sign it on your behalf. Especially when you are a child artist, usually it's the parents who will sign the contract on the artist's behalf. However, okay, a minor can contract for the necessaries, okay, but for a necessary or a simple contract, minor can enter, for example, a contract for food, clothing, medical treatment, and education under section 69. That's why whenever, you know, a kid going to a simple shop, okay, and buy maybe candies and chocolates, that is already a simple contract and a child can do that. Okay, so no problem. Okay, so how about employment? Okay, so employment, young person who is above 15 and below 18 are allowed to enter into employment contract under Children and Young Person Employment Act, but there are only a certain job that they can do. Okay, you can find out, okay, if you can just Google out Children and Young Person Employment Act under 1966. All right. Okay, last, okay, the element, okay, that seals off the deal of your contract is certainty. Okay, contract, especially the terms of the contract, cannot be vague and must be certain. An agreement, okay, which is uncertain, okay, all right, is void, meaning that you cannot accept an agreement that is vague. Okay, so the term of agreement must be clear. Okay, for example, I want to sell this computer, everything, okay, for 500 ringgit. okay, and I show to you, okay, the spec is this and that, okay, maybe it's MacBook Air 2015, things like that, okay, and for 500 ringgit. So it is clear, it is certain, and you know what I'm selling. Okay, the problem is when you said, okay, the term of agreement is vague in the sense that the timing is not clear, okay, meaning maybe this is something that you need to watch out also, especially freelancers when you take, okay, your further or your freelance job later on, okay, you need to put some time cap, okay, into your contract or agreement. Okay, so here in the case of Karupan, Chetty and Swatian, okay, the requirement of certainty is not met when the parties agreed, okay, to list the house 35 ringgit per month as long as he likes. So as long as he likes is not something that is certain, okay, it is uncertain. So you need certainty in contract because it's easier for both party to perform and to avoid any what we call as issue in the coming time later on. So that one, this is why the court will enforce, okay, would require certainty in your contract. Okay, so that is it for our part one of our discussion. We are, if you look that there is some thing that I skipped for this slide. Don't worry, we are going to discuss further in our tutorial. Okay, so please read through all, okay, the discussion up until the last slide. Okay, and this time around, we will not straight away jump into tutorial question. What I do is to make sure that you understand every element clearly, okay, and every concept and elements clearly. And please, okay, before I sign off, please do read the cases that I gave you. If you want to do some extra reading for it, perfect. Okay? All right, with that, okay, I thank you so much for your attention. Thank you so much for coming. All right, thank you so much for tuning in. I'll see you during tutorial and maybe next time. Okay, guys, thank you so much. Bye-bye.